Let us look at an area where, once again, psychiatry and law are wedded or intertwined almost irrevocably. And that area would be child custody litigation. And in my 40 years of doing child custody assessments, I've seen my share of litigation that seems to go on interminably, sometimes right up until the child has achieved majority, and on occasion even beyond that. I had a case where the former spouses were still arguing over custody of a now 27-year-old child. Obviously, there was estate and money, a lot of money involved, but it happens. And it seems to me there are two primary reasons why child custody litigation seems to go on forever. The first is that you don't get any clear, crisp closure. You don't get the kind of termination you get in most other forms of litigation. In the criminal courts, the man is either guilty or not guilty. There may be an appeal, but again, the appeal comes down guilty or not guilty. In personal injury litigation, either there was negligence or there wasn't. In child custody litigation, you don't have those crisp points of termination, and so such victories as you may obtain, such wins, endures only until the next motion is filed. And so we see again one motion after another, and such small victories are ephemeral and purchased at such cost as to be nearly indistinguishable from defeat. Even when you win, the child invariably loses. The second reason that I find child custody litigation tends to go on much longer than almost any other kind is that the attorneys, understandably, are focused on winning their immediate motions, on meeting their clients' immediate goals, rather than focusing on how can we bring litigation to a definitive end. The noted military historian Richard Bevan observed that the prescient, perspicacious general is perhaps less concerned about defeating the enemy today on the battlefield than in coming up with ways to vitiate the enemy's desire to continue to fight. That if you want lasting peace, you have to figure out what will stop the enemy from fighting. Otherwise, even though you may get a victory today, as soon as the enemy reloads, he's going to be back. So if you want lasting peace, you have to do something in a more long-term notion of victory. I believe that this approach is eminently serviceable in child custody litigation, where the focus should be not so much on winning today, winning today's motions, but in determining the least amount of force and the minimum number of concessions needed to get the other side to no longer wish to litigate. The least amount of force and the minimum number of concessions to get the other side to say, okay, we're done. The side which has been most successful thus far is the side best able to employ successfully this rather magnanimous